Good morning, Your Honor. Brian Neros on behalf of the plaintiff.
Good morning, Your Honor. Elena Lenz on behalf of the defendant.
Thank you. We have competing motions. One is a motion for partial summary disposition. I believe that was filed by on behalf of Ms. Keck, Alyssa Keck. And then we have a motion for psychiatric and custodial evaluation filed by Philip Keck. Let's take the motion for partial summary disposition first. Defendant's counsel, go ahead and argue that first, please.
Thank you, Your Honor. Whether the analysis of this issue is conducted under NCR 2.16 C5, C7, C8, or C10 is not particularly significant because the crux of the issue is whether plaintiff can proceed on a claim for custody and parenting time with defendant's 7-year-old child and 11-year-old child from a previous relationship under the equitable parent doctrine. And I will say this question brought me back to law school because I was reading quite a bit of case law in preparation for this hearing. But in looking at the existing case law that is out there, it's clear that this is a very fact-specific determination, and the facts of this case do not fall into the category of cases wherein the equitable parent doctrine has been applied. I understand that both defendant and plaintiff submitted lengthy briefs in support of their positions, and so I'm sure the court has had the opportunity to review those and has a good background understanding, but I do want to emphasize briefly some of the main points on that case law that I just referenced. The seminal case on the equitable parent doctrine is the Atkinson versus Atkinson case, 160 Mich. App 601, 1987. And that case did outline a 3-pronged test for the assertion of the equitable parent doctrine. Now, plaintiff properly cites that test in his brief, the 3 prongs being that there is a mutually acknowledged relationship between the parent and or the parent seeking to assert the equitable doctrine and the child, that the parent wants to have paternal or custodial rights, and that he is willing to pay support. However, what the plaintiff left out of the brief, and really important, is that that test is preceded by the phrase, a husband who is not the biological father of a child born or conceived during the marriage. And that emphasis, again, being on born or conceived during the marriage. That does not exist in this case. The parties have not even been married for 3 years, Your Honor. The children at issue in this case are a 7-year-old and an 11-year-old. And there is a companion case, case 2022-18962 DC, that establishes custody and parenting time for the 11-year-old and 7-year-old. And that is with the children's biological father, a Mr. Trevor Boren. Now, I do concede that the equitable parent doctrine has been applied to situations wherein the child was not born or conceived during the marriage, but application of the equitable parent doctrine outside of those circumstances is extremely limited. I think this can be seen in the case that plaintiff cited in his brief, the Washburn case. And it should also be noted that is an unpublished opinion, so it's not binding on this court. But in Washburn, the defendant was on the child's birth certificate, and the parties had acknowledged an affidavit of parentage during, and then thereafter during the divorce, it turned out that he was not the biological father, and that was proved by a genetic test. So again, in Washburn, there was a birth certificate and AOP on file. In this case, there is not a birth certificate with Mr. Keck's name on it. There is not an acknowledgement of parentage with Mr. Keck's name on it. Again, the children's biological father is a Mr. Trevor Boren, which makes it very distinguishable from the unpublished Washburn case. And one other point on case law, Your Honor, plaintiff's complaint for divorce in support of his claim for the equitable parent doctrine also acknowledged a Hawkins versus Murphy case, that being 222 Mich. App 644, 1997. It was not cited in plaintiff's brief, and I think that's significant because if you read the Hawkins case, it involved an order of filiation where the defendant in that case was the child's biological father through an order of filiation. So in that case, even though the child was not born or conceived during the marriage, again, we have this additional element, an order of filiation, similar to the Washburn case where there was a birth certificate and AOP on file. So I think that's significant. Again, that does not exist in this case. There is no order of filiation naming Mr. Keck as the biological father of the children. Defendant is sympathetic to plaintiff's position, but sympathy does not justify basically doing a legal limbo to extend the equitable parent doctrine to this situation, and it's not supported by case law. So we would ask for those reasons that defendant's motion be granted and hold that the equitable parent doctrine does not apply to defendant's 2 minor children from a previous relationship in which the biological father is a different party, Mr. Trevor Boren. And one last point on that, Your Honor, Mr. Boren's paternal rights have not been revoked, or they're still in existence. He has parenting time as agreed and arranged between the parties under that companion case I cited. Thank you, Your Honor.
All right. Plaintiff's counsel?
Thank you, Your Honor. In addressing the grounds raised by the defense for summary disposition, the ground under MCR 2.116C5 is not applicable. It wasn't timely raised, in that ground deals with capacity, which is a legal disability such as infancy or mental incompetency. It's not the same as standing that the defense counsels attempted to convey in their motion brief and reply brief. I believe the ground under C7 is also not applicable. It's not been timely raised. And even if this court finds that ground to have been timely raised, the elements for issue preclusion cannot be applied to this case. A clear aspect of the equitable parent doctrine is its application in the context of a divorce to ensure that the custodial practices of a party who seeks to be afforded the rights of a parent can continue. The very first element of the establishing case of Atkinson references the claim being raised prior to a divorce filing. I respond to counsel's comments about Atkinson. It's not the only case that decided or applied the equitable parent doctrine. It created the doctrine, which has been applied in many other cases under very different factual circumstances. And I think that's a very important part for this court to consider when making its determination today. Mr. Keck had not filed for divorce at the time of the referenced order between Mrs. Keck and Mr. Trevor Kibbe Boren. And so he did not have standing to raise that claim under the equitable parent doctrine to the 2 Kibbe children at issue. Meaning the question essential to the judgment in the Keck versus Kibbe Boren case under the equitable parent doctrine was not ripe for resolution because there was not a pending divorce between Mr. and Mrs. Keck at that time of entry. I further note that the issue between Mrs. Keck and Mr. Kibbe Boren is not the same as the issue in the current case. Obviously, we're dealing here with the equitable parent doctrine. It's not contested in any way that Mr. Kibbe Boren is the biological father of the 2 Kibbe children. The issue is whether this court will agree with Mr. Keck that he is in fact the natural father of these children under the equitable parent doctrine. The lack of a pending divorce case also prevented the element that requires the parties to have a fair and full opportunity to litigate the issue in that 2023 case between Mrs. Keck and Mr. Kibbe Boren. As a result of these 2 issues, there's no clear mutuality of estoppel between Mr. Keck and the present case, as he was not a party to the Keck versus Kibbe Boren case. He could not have been, again, because there was no pending divorce between the parties at the time. I note that the entry of the 2023 order between Mrs. Keck and Mr. Kibbe Boren does not deprive this court of its ability to enter another order. It in fact did enter prior orders in the parties' divorce case that was filed in September of 2023. At one point, Mrs. Keck was ordered to return the children immediately to the care and custody of my client, and she failed to do so, which resulted in a felony kidnapping charge against her. I move on to the ground for disposition raised by defendant under C8. I adopt in large part the argument made under C7 as to why this ground should be denied. Mr. Keck has asserted a claim upon which relief may be granted. The equitable parent doctrine is a readily ascertainable doctrine established by case law and has been discussed ad nauseum in the pleadings and briefs filed before the court today. The validity of that doctrine does not change simply because Mrs. Keck does not want its application to apply in this case. The application of a claim under the equitable parent doctrine is one that requires a factually specific argument and application, as conceded by defense counsel in her opening remarks. It's not something that can be or should be summarily dismissed, and it is a legitimate basis for a party to seek the status of a natural parent. Facts that have been considered compelling in courts in their application of the equitable parent doctrine do include the timing of the birth of a child in relation to the marriage between parties, but these facts are not dispositive, nor is the existence of names on orders of affiliation, affidavits of parentage, or the like. It's a very fact-specific analysis, and Atkinson made it clear that equity is to apply and broad application should be encouraged. Also, the best interests of the children need to control the court in any decision, and I believe that the best interests of the children need to include Mr. Keck's continued presence in their life. This court hasn't heard and won't hear any testimony on the best interest factors until August of this year. And so I don't believe that there's a basis to deny the claim under the equitable parent doctrine without at least hearing proofs. There's enough to survive summary disposition here, which leads me into the reasons for why the ground under C10 should also be dismissed. It's clear that there are genuine issues as to every material fact in this case, namely the facts alleged by Mr. Keck in his complaint that give him rise to the claim under the equitable parent doctrine, that he has a mutually acknowledged relationship with each of the Kibbe children that has been in fact facilitated by Mrs. Keck, that he desires to have the rights afforded to him as a natural parent, and he's willing to provide for them in accordance with the Michigan Child Support Guidelines. Mrs. Keck has denied all of these allegations in her answer to complaint, putting them plainly at issue. Mr. Keck has been the only father figure to the Kibbe children since they were ages 2 and 5. Their biological father, Mr. Kibbe Boren, which again is not contested, he has been incarcerated for a majority of their lives. The parties have discussed during the romantic relationship and marriage that Mr. Keck would proceed to adopt the Kibbe children and had every intention to do so. I again note that in the parties' initial 2023 divorce case, they both entered into a stipulation and order regarding marital counseling and parenting time. As stated therein, the parties were to continue residing in what they identified as the minor children, which included Caroline Keck, Kylie Kibbe, and Amelia Kibbe, and that parenting time for both parents should be reasonable and liberal, and that the parties will utilize one another when one is at work. I again reiterate that the best interests of the children need to be at the front line of the court's determination. The court again has yet to hear any best interest argument, as we are not set for any sort of evidentiary hearing until August. I believe all of these reasons argued today and set forth in our motion in brief allow this claim under the equitable parent doctrine to survive the summary disposition standard. So I ask the court to deny the motion on every single ground raised by the defense today.
All right, thank you both.
If I may, just briefly, Your Honor.
Certainly.
Thank you. I know both opposing counsel and I referenced that this is a really factual, specific determination. And again, the facts of the existing case law where the equitable parent doctrine has been expanded to circumstances where the children were not born or conceived during the marriage all involved birth certificates, acknowledgments of parentage, or orders of affiliation. Again, it is not a factual dispute that none of those exist in this situation. In reference to the 2023 stipulation and order for marriage counseling and parenting time, I don't think that should hold any weight to this court. That case has been dismissed, and that was entered in the context of the parties working on reconciliation, not proceeding down the divorce path. Moreover, unfortunately, we were not counsel on that case at the time, but I would have held the same position that was entered in error because there is no basis for Mr. Keck to be asserting the equitable parent doctrine for these two minor children. And finally, and I think one important thing to note is that the Child Custody Act does have a presumption for preference of parents between a third party, which would be Mr. Keck, and a parent. There has to be clear and convincing evidence presented that parental presumption should not be followed. So again, we would ask that the court find that the equitable parent doctrine does not apply to the 2 children that Ms. Keck shares with Mr. Boren, and dismiss on that point of this case, Your Honor. Thank you.
All right. Ms. Neros, in your brief on page 6, you cite the Washburn case. Are you aware of any other cases that would allow you to assert the equitable parent doctrine where there's not a child, a dispute, a marriage during the time that the child was either born or conceived?
Your Honor, I was unable to find any other cases outside of the context of same-sex couples prior to Obergefell v. Hodges that addressed and applied the equitable parent doctrine to the birth of a child prior to marriage. However, I believe the concept of the equitable parent doctrine in Atkinson that has been echoed throughout various other Court of Appeals opinions, that the concept is in fact based in equity and should be liberally applied and construed, while also allowing the best interests of the children to guide the court in its determination and application, make it open the avenue for this court to allow the claim under the equitable parent doctrine to continue, or at least survive summary disposition until the court can hear further proofs as to my client's involvement in these 2 children's lives and the benefit that he has had for them. I'm aware that our motion for evaluations is also up for hearing today, and I believe that might give the court some additional insight as to the concerning conduct exhibited by Mrs. Keck and how my client addressed and was present for the children during those exhibitions of conduct. But to bring it back to the court's question, I think the general statements of it being an equitable doctrine and must be liberally construed, again, affords this court the route to continue hearing argument under the equitable parent doctrine.
All right. Thank you very much. I appreciate that. My review of the case law is as follows. I have reviewed Atkinson versus Atkinson as the parties have cited it. It has under the equitable parent doctrine requires the spouse to be married to the mother at the time of conception or birth, even if they're not the biological dad. That was followed up, and neither party has cited it, but that was followed up in Pueblo v. Haas from the Michigan Supreme Court in 2023. That's 511 Mich 345. And it may be that the parties, this is a same-sex couples case, but it reaffirmed what the law was under the equitable parent doctrine. And it says that standing of an equitable parent requires showing that there was a marriage at the time of conception or birth. In this particular case, it also said, or that there would have been such, but for the illegal same-sex marriage law that was overturned in Obergefell. So as recently as July of 2023, the Michigan Supreme Court has reviewed the issue and has required that there be that marriage relationship in order to assert the equitable parent doctrine. In addition to that, I also reviewed Van versus Zahorik from 460 Mich 320 from 1999, which again is a Michigan Supreme Court case applying the equitable parent doctrine, but not extending it beyond the marriage relationship. Finally, I reviewed the Washburn case. It's been cited by both counsel. I would point out that it is a dissent only, and it is an unpublished decision. Further, the dissent cites to the, this is the Michigan Court of Appeals case. It cites to the Michigan Court of Appeals case on Van, which is the Van Zahorik case that I just cited. And then that case, the Washburn case says, the dissent says that it would, it is bound by prior requirements of the Supreme Court to say that the marriage requirement is a requirement, and then it would ask the court to change it. However, 3 weeks later is when the Michigan Supreme Court decision in Van came out, and it declined to change it. So the Washburn case, in my mind, it has absolutely no authority value for 3 reasons. It's unpublished, it's a dissenting opinion only, and then it bases its opinion on the Michigan Court of Appeals decision in Van, which was not taken up was not affirmed on the Supreme Court decision in Van. So for all of those reasons, I find that because there was no marriage relationship to the two by the plaintiff in regard to the two older children, that the equitable parent doctrine, by operation of law, is not applicable, and therefore there is no ability to make that claim. And so I'm going to grant some partial summary disposition as to the older two children based on that analysis of the equitable parent doctrine. So defense counsel, if you would be so kind as to submit a proposed order saying that. Now let's turn to the issue of the psychiatric and custodial evaluations. Ms. Neros, if you would argue that, please.
Thank you, Your Honor. Mr. Keck filed his motion requesting that Mrs. Keck and, excuse me, the children, which originally included the Kippy children, to submit to an appropriate evaluation, including psych and custodial evaluations. He's also willing to submit and participate in these evaluations as well. I note that the Child Custody Act governs all issues related to minor children, including those of custody and parenting time. As part of that act, the court is expressly authorized under MCL 722.271D to utilize resources such as psychological and custodial evaluations and use the recommendations of those evaluations to resolve any pending custody dispute before it that will best serve the interests of minor children. I cited what I believe to be some of the best interest factors at issue in our motion, but I believe it's also reasonable to state that those factors under MCL 722.23A, B, and J are also at issue. I note that MCR 2.311A provides additional authority requiring requesting the examination of a party. The defense has not necessarily agreed with the position that the mental condition of Mrs. Keck is at issue, but I believe that the authority under the Custody Act allows the court to nonetheless require Mrs. Keck to submit to an evaluation. I don't concede that her mental condition is not at issue. We believe it, in fact, is readily at issue. Namely, because during the parties' relationship and throughout their marriage, Mr. Keck has observed Mrs. Keck to fail to take prescription medication for her mental health in accordance with the prescriber's recommendation. He has observed her to utilize marijuana instead of those prescribed medications. Mrs. Keck has also engaged in behavior that is nothing short of problematic. I note that a big issue during the parties' 2023 divorce case was the presence facilitated by Mrs. Keck of a Mr. Adam Greenman. He's an individual who Mrs. Keck began a romantic relationship and had the children around. Mr. Greenman had lost his parental rights to his own child as a result of the abuse he committed upon his child. Yet Mrs. Keck continued to bring herself and the party's biological child around that individual. Mrs. Keck continues to utilize individuals to care for the children who are dangerous while she leaves them alone for extended periods of time. We have reason to believe that Mrs. Keck has been allowing the children to stay with a Miss Dawn Boren, the mother or some relation to Mr. Trevi Kibbe Boren. She's an individual who has threatened to commit severe bodily harm and threatened the life of one of the children. I further note that Mrs. Keck herself has committed harm previously to children, and one of the Kibbe children suffered a traumatic head injury because of her conduct. Mrs. Keck has been a suicide risk, necessitating the presence of law enforcement. Upon law enforcement's arrival and my client's presence there as well, a pistol was found to be in close proximity to her. And I note that Mrs. Keck has failed to ensure that the children regularly attend school, including Caroline Keck. I note that this court was informed of Mrs. Keck's concerning past in the motion to compel discovery and or dismiss for lack of probable cause that my client's defense counsel filed in the district court case 25-43388-SM. As part of that, I note that Mr. Keck's assertions of self-defense were gone without any regard. I note that Mrs. Keck has offered FaceTime visits between my client and Caroline, but there's no reason for Mrs. Keck's contact to be so limited. She's withholding the child from him for no good reason. There's nothing in his bond conditions that prevent him from having any contact with Caroline, and the unwillingness of Mrs. Keck to facilitate a relationship between him and their young daughter is a problem. Mr. Keck has been away from Caroline and has not seen her for any notable period of time since January or February of this year. I note that Mr. Keck is unable to be at his own home at the present time, but he is able to be on either the same parcel, just in a different structure, such as a pole barn or something. There's a fence that separates that part of the land from the marital home. Mr. Keck has been at a place where he's permitted to be, and Caroline has run up to the fence and called out for him in hysterics. And yet Mrs. Keck has not allowed any sort of contact between Mr. Keck and Caroline. To put it succinctly, there's a pending custody issue before the court. I believe it has explicit authority to order the parties to submit to psychological and custodial evaluations and to allow the minor child to participate in that as well. I believe having the opinion of a qualified third party will help this court in its resolution of the best interest factors that are yet to be formally before it. And so I would ask that this court order the parties to attend such evaluations, and Caroline Keck as well. And my client would be responsible for whatever portion of the cost the court deems appropriate. Thank you.
All right, Ms. Lentz.
Thank you, Your Honor. So when I reviewed plaintiff's motion for the psychological and custodial evaluation, it seemed to be based on three main points. One, that defendant is allegedly in a relationship with a new romantic partner, that defendant is allegedly withholding parenting time, and that defendant has alleged domestic violence against the plaintiff. Those 3 points are better explored under other best interest factors. They're not related to the mental health of plaintiff nor defendant. For example, if plaintiff did have a new romantic partner, that would be better explored under MCL 722.23E, the permanence of the proposed family units. In regard to the withholding of parenting time allegations, that would be better explored under MCL 722.23J, willingness of the parties to promote a relationship. And similar to the allegations about domestic violence, there's a specific best interest factor, factor K for that, trying to use mental health as the caveat to exploring romantic partner, romantic partner withholding parenting time and domestic violence is not appropriate. I believe the term I used earlier was legal limbo. We're doing the same thing again. We're trying to bend so that we can fit into the court rule. Now, MCR 2.311A, the rule pertaining to subjecting a party to a evaluation for their mental condition, that's a two-pronged test. First would be establishing that someone's mental health is in controversy. For the reasons I just went through, I don't think that the plaintiff has proved that defendant's mental health is in controversy. There was a lot said during oral argument that was not contained in the motion, and therefore I don't have necessarily the time to address all of that. But for example, reference to marijuana. Your Honor, if marijuana is going to subject people to a mental health evaluation, we're in a lot of trouble because there's going to be a lot of people in court filing for that. But I don't think it's in controversy. And if you can't show that someone's mental health is in controversy, you don't move to the second prong of the test, which is good cause. So as to the psychiatric evaluation, I do not believe that we have met the test under MCR 2.331A that would require my client to undergo an evaluation. And I think that's a pretty significant request in that there's several HIPAA basically waivers that someone has to concede in undergoing a psychiatric evaluation and then having the contents of the same being used in litigation. As to a larger custodial evaluation, the minor child in this case is 3 years old. I think that the information gleaned from subjecting a 3-year-old to a full custodial evaluation is not going to rise to the level that warrants the intrusion of the same. In the event that the court does decide to grant plaintiff's request for a psychiatric and custodial evaluation, we would request that plaintiff bear 100% of the costs of the same, given that he's the one making the request, Your Honor. Thank you.
Your Honor, if I may respond just to a few brief points.
Certainly.
Thank you. I argued in the alternative that this court nonetheless has the authority under the Child Custody Act to utilize resources, which would include psychological and custodial evaluations. The allegations that I relayed verbally today have been contained within my motion. A large part of them stem from conduct exhibited by Mrs. Keck and were memorialized in the motion that I referenced filed in my client's pending other matter. The allegations about the three things that Ms. Lentz believes to be the crux of my motion of a new relationship, withholding parenting time, and domestic violence, those are all things that, yes, are considered under the best interest factors, but need to have some further psychological and professional evaluations to really get to the root of what's going on. If Mrs. Keck doesn't believe that it's a problem to be subjecting young children to new individuals, to be withholding a child from her biological father, to have all of these issues without more, that seems fully contrary to the best interest of the children. I don't believe the age of Caroline should be dispositive. She's been ripped from her father and has not been allowed to see him because of conduct by Mrs. Keck. I believe, regardless of the age of a child, such deprivation is going to have severe psychological trauma that should be addressed now. And we should have a parenting time arrangement that will prevent any future harm going forward. This court is authorized to have such evaluations done to assist in its determination and findings under each of the best interest factors. And I don't believe that requiring a party to submit to an evaluation would be contrary to anyone's best interest. The mental health is at issue simply because there is a pending custody dispute, and the mental health of the parties is a factor considered with the best interest factors. I believe having a qualified professional to really dig into what's going on and what's happening to cause Mrs. Keck to act in the manner she is will only help this court in creating a custody and parenting time plan that's truly going to help these kids, will help Caroline move forward after not being able to see her father regularly since February. I again assert that Mrs. Keck has failed to take prescription medication that she's prescribed in accordance with the recommendations of her physician. So I believe that there is a readily available basis to find that her mental health is in fact at issue if this court is not inclined to adopt my argument under the Child Custody Act that would allow them to order evaluations. Thank you.
Thank you, counsel. You made Ms. Neros, you made a statement in your initial arguments that your clients, in the district court manner, that your clients' self-defense claims were gone without any regard. What are you referring to there?
I believe a large part of the motion in the criminal case was the affidavit of probable cause. My client expressed to police officers he was I don't want to speak too much about it given that the case is pending, but he informed an officer that he was first struck by Mrs. Keck. And the officer later in reportings made it, his position was that it was not clear to him who the aggressor was. Yet my client was the one that was charged. And so that motion details in a history of instances where Mrs. Keck engaged in conduct that is gleamingly criminal in nature, yet she's evaded any sort of criminal charge. She's forged checks from my client's business account. She's done a lot of things and committed a lot of harm and has
Ms. Neros, I'm not asking you to repeat the arguments that I heard for the district court self-defense and allegations. What I'm asking is, what did you mean by the statement that his self-defense was gone without any regard? Who are you referring to, and what are you referring to?
I'm referring to the existence of his criminal case. If it wasn't clear.
Who did you say made the determination that his self-defense claim was gone without any regard? Who are you referring to? Is that the judge, me? Are you referring to the police, or who are you referring to?
I believe that was it. I'm asserting that in how the probable cause arrest warrant was issued, there wasn't any mention of it in that form. And that in turn resulted in the motion to dismiss being denied.
Are you saying that I did not give any regard to his self-defense claim? Is that what you're alleging?
Essentially, yes, Your Honor.
All right, I just wanted to make sure I understood your argument correctly. All right, any other statements or any other arguments that you wish to make before I make my ruling?
No, thank you, Your Honor.
All right. Are there any documentation of the claims that you've made in this case, Ms. Neros, other than the district court case that you referred to? Any other additional factual documents that support Mr. Keck's claims as to mental health issues with the plaintiff in this case, excuse me, the defendant in this case, Ms. Alyssa Keck?
There are police reports or investigative reports related to the suicide incident or concern of suicide risk from December. But my client's personal observation with respect to like consumption of medication and lack of compliance would be really the only other source that I have.
Your Honor, and just for the record, I'd like to object to any references to the police reports unless the officer is here to testify to the content of the same.
Well, all right, so noted. My concern, Ms. Neros, is that none of that was attached to your motion. So what I have is your arguments. I don't have any specific facts upon which to make that determination. In the district court case that you referred to, there were police reports of every single incident that was used as a basis for the argument. And I went through and reviewed each and every police report and made a finding as to how I believe that resulted in information or a lack of information. And I made determinations as to the specific facts particular to that case. I did not in any manner disregard any of the facts. My conclusions are at odds with Mr. Keck's conclusions, but I based it on the facts of those documents and made a specific finding as to each and every document. This case doesn't have that. So if you're asking me to use the information that I had from the district court case, I can do that. But as I've indicated before, my conclusions based on those factual determinations are entirely at odds with Mr. Keck's conclusions. I have no factual basis before me today to grant you a independent examination for mental health purposes. You've not given me good cause to do that. The fact that your client has observed his, at the time, spouse not taking some medications is admissible. You can use that in the best interest factors, but I don't believe it rises to the level of saying that she needs to have an independent examination in front of the child. There's no evidence before me that lack of taking the medication or that the quote suicide attempt had any impact on her ability to be a parent for the child. And that is what's required before I'm going to grant any request for independent examination for mental health purposes. If a person, let's assume the worst case scenario, if a person is crazy when they don't have the child, but when they do have the child, they're acting perfectly normal, there is nothing within the law, as I understand it, that prevents them from having access to the child. It is what is the impact of the parent's behaviors on the child? Can the parent, in the best interest of the child, parent the child? I have nothing before me on a factual basis today that allows me to conclude that I would be helped in any way by an examination as to mental disability or mental inability by an expert. And so for that reason, I'm denying the request. Ms. Lentz, would you prepare a proposed order for that as well?
Yes, Your Honor.
All right. Does that address all of the issues before the court today?
Yes, Your Honor. Thank you.
Yes,
All right.
Your Honor.
Thank you.
Thank you.